We've talked a lot about patents, but not everything is appropriate for patents, and there's actually law that allows you to keep trade secrets called the Uniform Trade Secret Act. And this can be used for information, including a formula, pattern, compilation, program, device, method, technique, or process that, number one, derives independent economic value from not being generally known and is not readily ascertainable by proper means, and is the subject of efforts to maintain secrecy. So if you think of the formula for Coca-Cola or for the special seasoning for KFC, these are types of trade secrets. They have economic value because they give a unique taste, and the company is actually trying to keep them a secret. This is a different approach than patents, so it's only useful if it's not disclosed. So why would you do that? It might not be a good idea to disclose. In that case, it might be better to try to keep it a secret. And how do you do that? Well, you can have contracts that say that others cannot disclose what they know about this trade secret, and they cannot compete. And who would you ask to sign these contracts? Well, typically they're the people that have access to the secret sauce. So those are employees, potential or existing partners that need to know this before being partners or they're involved, or potentially investors, and we'll come back to that in a second. This is an alternative to patenting. So patents are useful for inventions, processes, methods. As we discussed, can be used for plant varieties. And trade secrets can be almost anything that helps to give you a competitive advantage. When would you use one or the other? You can pick one, but not both. And the idea is that these two types of intellectual property protection are mutually exclusive. A patent requires you to disclose information about the invention, and then a trade secret is based in secrecy, not disclosing. So for the same type of intellectual property within your company, you can't use both. Some of the differences: patents give you a 20-year term of protection, but trade secret, you can potentially keep it a secret forever. A patent gives you exclusive right. A trade secret does not preclude others from trying to reverse engineer your product or your service. You can't patent everything. Trade secrets is really broad. Both can be expensive. Patents, you have to pay the money to actually file the patent. Trade secrets, you have to pay money, put time and effort into maintaining a secret. Patents, as we've discussed, can take a couple years to actually file and issue, while trade secrets, you can have the protection immediately. One thing that comes up a lot in entrepreneurship is this idea that an entrepreneur will go to an investor and they want the investor to sign a non-disclosure agreement because the idea is patentable. If you were the investor, how would you respond to that? We've just talked about how these, trade secrets are important and intellectual property is really important. An investor, let's say someone who sees a lot of different ideas, they are unlikely to sign a non-disclosure agreement. A non-disclosure agreement will tie their hands and make it so that they can't invest in another company that may have similar intellectual property and may even be better, and so an investor doesn't want to do that. And also an investor, a professional investor, their reputation is very important to them. They would not disclose secret information to competitors because they would lose their reputation. And so it's kind of a sign of lack of trust if you want them to sign that really early on. Now, eventually when you reveal the secret sauce and everything, that might be appropriate, but definitely not at the beginning. To make sure that you're not damaging or disclosing intellectual property in a way that's foolish, what you need to do is you need to only work with investors who are reputable, and you don't need to put every part of the secret sauce into a business plan. That's just not necessary. So a few things to consider: it does take time and money. Sometimes things can be reverse engineered, and so if you can reverse engineer something a trade secret is not super valuable because the secret can get out just by trying to reverse engineer your product. You might want to think about the shelf life of your invention, if there's going to be better products and services out there very shortly because technology is progressing. You might want to think about that. And then also how many people have access to the invention. If there's just a few people who know the inner workings, that might work better for trade secret. Look at all these letters here, see if you recognize any of them. And what's very interesting is that many of these trademarks have gone away now. You can see here the A, that's the A from Sears. Sears is no longer functioning. You can see M from McDonald's. The R from Radio Shack. Radio Shack's now gone. Why do we care about these letters? Well, because they're trademarks, and trademarks or service marks imply the origin or source or nature or quality of a good and service. So when we see these things, we recognize where they come from, or that they are higher quality or better in some way. So that's why they matter. And they're protected by law. They actually show up on a balance sheet, and it's part of goodwill. And trademarks and service marks can be almost anything, and if you continue to protect them and apply for protection, they can last indefinitely. So you just have to keep filing for that. So the owner of a trademark can prevent others from using the mark for similar services. So you have to file this with the U.S. Patent and Trademark Office, and you have to have some quality control. And if there's other companies that are infringing on that, you do have to attempt to enforce the trademark. Otherwise, your trademark becomes generic and no longer enforceable. Here's some examples. You can see these are from other countries, but the key thing that I want you to remember from trademarks is that trademarks are based on the likelihood of confusion. First, you have to have something that is of value. You already have to build a brand before your trademark really has value. So you can't just get a name and say, oh, somebody else is using my name. People actually have to recognize your name or your mark. Trademarks are actually more important for established companies. And if another company infringes on their trademark, they can take them to court. And again, just like with patents, you got to sue them and potentially get some of their profits and damages. But again, you have to take them to court. And obviously, anything with intellectual property is based on the jurisdiction in which you are operating. It's easy to file a trademark. Trademarks are based on specific types of goods and services. So just because someone else uses a name doesn't mean that you couldn't use it if you're using it for a different type of product or service.